Vegas just dead. Like no one was on the strip. It was so eerie.
It was.
You have a meeting?
And to be honest, really, Nevada is mostly the desert, so the COVID numbers have never been that bad here. And part of it is because our governor, instituted a mask mandate immediately, shut things down immediately. People pretty much obeyed the shutdown, obeyed the mask mandate. And again, Nevada is very spread out, it's mostly desert. So it was never really that bad here. But yeah, to see the touristy part, the Las Vegas Strip, to see that totally, shut down for like 2 months was eerie, but it really helped with, containing the numbers because it really hasn't been that bad out here. And, and I think now the numbers have been like maybe 300, new cases a day. And about 40% of the population, is at least partially vaccinated. So it's never been that bad. The worst places are the very densely populated cities like New York City, Southern Florida, and of course, Southern California. Those places are so densely populated, and Detroit, Chicago, places like that.
Yeah,
But
Michigan
yeah,
was, I think we were the worst. I think we've been the worst state this past month. I think we had 11,000 cases in one day a couple weeks ago. But it's
that's
because we're shut up
heartbreaking.
we're shut up so much in our house during winter, and like once it gets warm out, everybody wants to go out, and it's just anyway. I'm so tired of COVID.
It is.
I
It's
can't
very
stand
frustrating.
it. Yeah, it is.
Yeah, I'm tired of wearing the mask. I admit it. I've been wearing the mask now for over a year, and I'm fully vaccinated. But I went to the store today, and I still had to wear the mask, and I was like, "Geez, I'm getting tired of wearing this mask." But when I was in Utah, the mask mandate's been lifted there, so I didn't have to wear it everywhere. So it was nice to be on vacation for a couple of days and not have to wear the mask.
Hi.
Hello. I joined the meeting.
Hi, Yolanda. How are you doing this week?
I'm doing good. I overheard y'all talking about COVID. Yes. I lost my aunt to COVID about a week and a half ago. So
I am so sorry. I am so
thank
sorry.
you. She took that Johnson & Johnson shot. And I know they removed that already. They're going back to Maduro and Pfizer, I guess. I'm not too sure the name of the other ones.
Yeah, the other two that have been authorized for emergency use are Moderna and Pfizer.
Right.
And to be honest with you, I personally would never get the Johnson & Johnson because it is not using the newest technology. The newest technology is the messenger RNA technology, which is what Moderna and Pfizer are based on, which messenger RNA simply just tells your body basically to create an antibody that can recognize the outer spike protein on the coronavirus and keep that from entering into cells. So the a vaccine based on mRNA technology does not have the virus in it, and that was one of the myths you kept hearing people say, oh, if I get the virus and I'm going to get COVID. No, if I get the vaccine, I'm going to get COVID. No, the Moderna and the Pfizer vaccine cannot possibly cause anybody to get COVID because they don't have the virus in them. They have messenger RNA, which simply tells your body to create antibodies to fight off the outer spike proteins that the COVID tries to use to attach to your cells and enter the cells. So I definitely don't recommend the Johnson & Johnson vaccine. And the Johnson & Johnson vaccine at most is 60 to 80% effective, whereas Pfizer is 95% effective. So I wouldn't, I feel sorry for people that have had to suffer through the Johnson & Johnson vaccine. And I feel terrible for anyone, of course, who's lost a loved one. It's been such a difficult year, it really has. And I'm just glad that we're all here together and that all of you have come to join me for the last live session, which is the Module 5 live session for the for the legal ethics course. Any questions before we get started? Let me try to unmute everyone. If you have any questions, type them in the chat box. Let me unmute all. Yeah, if you have any questions, otherwise we will go ahead and get started. Okay, so this is the last live session that we will have for this 5.5-week course. Next week is the half week. So that module ends on Tuesday. We won't have time for a live session. I'll have a pre-recorded live session video that I'll post like Sunday evening. It'll give you a quiz review for the Module 6 quiz. So this week we are talking about the consequences and the attorney disciplinary proceedings and the legal malpractice actions that can happen as a result of violating these professional rules of conduct that we've been learning about all term. So let's talk about some of the consequences of unethical conduct. Just a reminder, the last day of class is Tuesday, May 11th. Please be sure to submit all of your assignments by Tuesday. No assignments can be accepted for a grade after Tuesday unless you have an incomplete grade. Okay, so let's talk about the fees that an attorney may charge for services, because the professional guidelines do regulate how much an attorney can charge. What do you think would happen, Yolanda, if there were no guidelines regulating how much attorneys could charge? What do you think would happen? What do you think would happen, Adrian, if there were no guidelines?
I think everybody would just say, well, this is how much I'm worth. Boom. $1,000 an hour. Yeah, anybody could do whatever they wanted.
Exactly. So there are regulations. Under ABA Model Guideline A, a lawyer may include a charge for work performed by a paralegal in setting a charge and or billing for legal services. ABA Model Guideline 9, a lawyer may not split legal fees with a paralegal, nor may pay a paralegal for the referral of legal business. A lawyer may compensate a paralegal based on the quantity and quality of the paralegal's work and the value of that work to the law practice, but the paralegal's compensation may not be contingent upon the outcome of the case. So let's talk about these fees. Usually, an attorney is allowed to charge a reasonable fee, and the reasonable fee is usually set by the standards within the attorney's specialty and within the attorney's locality. I've seen business lawyers charge maybe $400 or $500 for some of the work that they do for business clients. I've seen insurance attorneys who represent insurance companies in personal injury cases, be able to charge maybe $200, $250 for the services that they provide, because again, the insurance companies will only pay so much. But certain attorneys in personal injury and tort cases, the plaintiff's lawyer may be representing an injured party who cannot afford to pay the fees up front. So that's where contingency fees come in. So a contingency fee would be the lawyer only gets paid if the lawyer, if she wins the case for her client. So if the lawyer wins the case and the lawyer gets paid, the lawyer may get, anywhere maybe up to a third, and the law won't allow any more than that of what the personal injury client's recovery is. That'd be a contingency fee. An attorney is not allowed to pay a paralegal based on a contingency. And, that's because the paralegal may work very hard on a case, and the judge might still rule against you, or the jury might rule against your client. And that would mean the paralegal would not get paid if the paralegal's pay was a contingency fee. So an attorney has to pay a paralegal for the time and the quality of the paralegal's work. The attorney cannot make the paralegals pay contingent upon the outcome of a case. So that's important to know that, as a paralegal, you'll always get paid. Your boss may not get paid, but you will always get paid. And ABA Model Guideline 20, a lawyer who employs a paralegal should facilitate the paralegal's participation in continuing education and pro bono public activities. How do you all feel about doing pro bono work? After you spent your time and money to get your paralegal certificate, are you interested in doing pro bono work after you graduate? Any interest there in doing pro bono work?
That's pretty much one of the only reasons I'm going to go and do all of this is because I work with a nonprofit and they need help. So that's my main concern, actually. I don't care about getting paid at all.
Good, good. And again, if you work for a nonprofit organization, that hires employees, fortunately, you probably still will be compensated for your time. And if the work that you do helps to serve the interests of the public good and you're helping people in the community, that's just a win-win situation, Megan. Anyone else? Any opinions on pro bono work?
Yeah, I have absolutely no problem doing that. I think I would enjoy it. But I do want to get paid, like Megan.
Yes, yes.
For the pro bono, obviously.
Yes. I've only done pro bono work twice in the last 25 years. And I actually spent, I guess it was 2 days last week doing some pro bono work. It was a fair housing issue, and a group of people wanted to have some attorneys, do some research about the issue with fair housing and how that affects former inmates people who have come out of prison, have served their debt to society, and now they want to get reacclimated into society, and the challenges they overcome in finding housing and employment. So anyway, I spent a couple of days doing pro bono work and attended a fair housing meeting, and it was refreshing. I actually, enjoyed doing that. It was something different, and it was fun to be, doing something for the community for 2 days. And really, I haven't done any pro bono work before that, like since 1998. Just didn't really come up, but when it comes up and there's an opportunity, it's always fun to jump in there and volunteer. And I really have done a lot of volunteer work. I just haven't done a lot of pro bono work lately, but I do enjoy it, when that opportunity comes up to do that. Okay. So again, ABA model guideline, a lawyer who employs a paralegal shall facilitate the paralegal's participation in appropriate continuing education and pro bono activities. Again, showing that people in the legal profession really do have a much higher code of ethics and a dedication to society and an obligation to society to do some work for the public good. Because the law is here to serve society and to maintain order. And when we work in the legal profession, I think we're expected to, to keep that in mind, that we are here to provide a service to help. All right, let's talk about the model disciplinary rules and the ethical considerations. Rule 1.1, a paralegal shall achieve and maintain a high level of competence. Ethical considerations, EC 1-1, a paralegal shall achieve competency through doing what you're doing, education, training, and work experience. A paralegal shall aspire to participate in a minimum of 12 hours of continuing legal education, to include at least 1 hour of ethics education every 2 years in order to remain current on developments in the law. A paralegal shall perform all assignments promptly and efficiently. So I do find that continuing legal education, is sometimes inconvenient when you're very busy working, but at least it's only every 2 years. And within your community, the paralegal organizations will have all the information you need about how to sign up for those continuing legal education courses. And they will be interesting, you know, especially if you just divide it up 6 hours of continuing legal education a year. It won't take too long. Okay, let's take a look at one of these ethics board opinions, 08-01. So in this case, a paralegal had an ethical question and she submitted that to the state board. And here's the answer she got. What are a paralegal's obligations and responsibilities when an attorney becomes impaired due to age or disability? And you see this happening a lot, is attorneys age. I worked for a law firm for a while in Northern California, and it was in the 90s when some older attorneys were just being introduced to personal computers. And there was one attorney, Doug. He was a great guy, but he just was having a hard time adjusting to doing things with the computer. So one day he called in tech support, and his computer was on. He was having problems with it, and he just yanked the plug out of the wall. And he told the person in tech support, "I want you to show me everything about how to use this computer from start to finish." And the person was like, "Well, first of all, yanking the plug out of the wall is not the proper way to shut down your computer." you know so sometimes you're dealing with attorneys that are aging, and they're changing, and sometimes attorneys reach a certain age where Alzheimer's or something else could be affecting them. So what would a paralegal do who works for an attorney who's advanced in years when it becomes increasingly clear that the lawyer is beginning to show the effects of their age, and maybe they're forgetting items on the calendar, they become disoriented when traveling? Sometimes attorneys are required to travel out of town for depositions, um, or the attorney thinks that they've completed some work when they haven't completed it, because getting older does affect your memory. So, well, the opinion holds is that this could actually lead to legal malpractice. The paralegal might be under some ethical obligation to report the behavior of an attorney who is impaired to the state bar ethics hotline, maybe to a managing attorney that works within that firm. What would you do in that situation, Adrian, if you were working with an attorney who is becoming impaired due to age or disability?
Uh, ac- Actually, in our building, we have a couple attorneys like that, and one of the paralegals, she actually just quit because she couldn't deal with them anymore. But anyway, I think if you're in a law firm, and there's other attorneys there, you could probably go to them and get their advice on who to go to. But I think if you're by yourself, like this woman, she tried to talk to so many different people, and he had such a community of other attorneys that they just kind of protected him. So that's why she quit. But so in that case, I don't know. I guess you would just have to go to, I don't know, the state and find out from them or his wife. So, but I think if you're in a law firm, you would just, you would have to talk to the authorities of the law firm and then go from there. I think.
Good. And that actually, you've raised several issues, and I'm just going to tell you about a true story because it completely fits in. My roommate in law school was always a little bit self-righteous, and she chose to go to work for the city attorney. One thing that the city attorney does is the city attorney is involved in approving government contracts, and when there's bidding on public works contracts to build roads, to build developments, to do sewer, to lay pipe, eventually certain contractors become very preferred for certain contracts, when in reality the law requires an open and fair bidding system. But I'm sure you all are familiar with the fact that sometimes there's favoritism in handing out public works contracts. So my friend from law school, she observed some favoritism in how public contracts were being handed out, and she decided to report that to the city council. What do you think happened to her? She's the only female working in this office of all men. What do you think happened to her, Adrian?
She probably got let go. Or,
She did.
yeah,
And
or, they probably treated her like Miss Okay, sweetheart, how it was back then.
Yeah, and I think this probably happened about maybe 8 years ago or so. And so yeah, there was there is always a question of when you are faced with an ethical dilemma, whether you choose a course of action that leads to the greater good. In this instance, what is the harm of a little bit of favoritism in handing out public contracts? That's always going to happen, right? Because certain government officials have friends who are contractors and developers, and they realize certain contractors can get the work done maybe for less or for more. And so anyway, yeah, this my friend reported that, and she got fired. And she claims that people started calling her house, harassing her. When she would take her kids to the grocery store, there'd be somebody following her. I mean, this made the news. It was in the news, and I felt sorry for her. And again, it was a question of, when you observe unethical conduct, how do you handle it? And reporting that conduct may not always be the best solution for you personally if you would like to maintain your job and your reputation. Because I can tell you that my old roommate, I don't think she's worked a day as an attorney since she tried to report the city's attorney for favoritism in public contracts. And this wasn't a life or death situation. So, how you choose to handle an ethical dilemma is going to determine, the direction that your career takes. And as Adrian pointed out, the woman that was working within the same building that you're working in, right? She tried to say something, but the good old boy system, they all backed the attorney, and she got fired, right? Or did she have to leave, or did she get fired?
She quit. I mean, because she had been with them for a long, long time, and they loved her too. She was part of the good old boy stuff, but they weren't going to do anything about it. So she was like, "My hands are tied. I'm quitting."
Okay. And yeah, maybe sometimes that's what you have to do, is remove yourself from the unethical situation. So she is at least no longer liable for it. She's not contributing to it. She is not involved in the unethical conduct anymore. So that's the difference between the rules on the book and how things play out once human beings get involved, right? It's not always fair. So you do have to pick and choose your battles. And, like my former roommate, I feel sorry for her, because I personally would not have said anything in that situation, because it's not a matter of life or death that certain contractors are being favored when it comes to the distribution of public contracts. It's not a life or death matter. And saying something will only cause you to lose your job, while everybody else is still at happy hour laughing about the last contract they signed. It's just, so that's always an issue. And I would encourage all of you to consult with someone else in the legal profession when these ethical dilemmas arise. And you can even write down a plus or minus list. What are the pros and cons of how I choose to act when I am faced with a dilemma? Am I going to do everything by the book, and is that going to work, or is it just going to lead to a situation where I have to quit? So. Okay, let's talk about this model disciplinary rule 1.2. A paralegal shall maintain a high level of personal and professional integrity. Paralegals shall not engage in any ex parte communication involving the courts or any other adjudicatory body in an attempt to exert undue influence or obtain advantage or the benefit of one party. A paralegal shall not communicate or cause another to communicate with a party the paralegal knows to be represented by a lawyer in a pending matter without the prior consent of the lawyer representing such party. Paralegals shall ensure that all timekeeping and billing records prepared by the paralegal are thorough, accurate, honest, and complete. So a lot of things come to mind here. So ex parte communication, what that is, ex parte is Latin for one side. So if you've noticed, if you watched any court TVs, if an attorney makes an objection to testimony, and maybe they ask for a sidebar and they want to speak to the judge out of the ear of the attorney, both attorneys come running up to the judge, right? Objection, Your Honor. Counselor, come to the bench and we'll discuss it. You see both attorneys running up, right? Because nobody from one side of the case is allowed to have ex parte communications with the judge, because that looks like you're trying to get some kind of favoritism from a judge who is supposed to be impartial. Now, this is a real scenario. A friend of mine got stopped for a traffic ticket and decided that the best way to handle this traffic ticket was to hire an attorney. And he chose to hire a very attractive female attorney. And the attorney walked into court and said, I used to date the judge. So guess what? What do you think happened in my friend's case? What do you think happened, Adrian?
Well, if they parted on good terms, he probably got off of the ticket. But if the judge was
Exactly.
mad at her,
No, they were still friends. And so, yeah, my friend got off. He paid the lawyer. This was a while back, so it was like $500. She handled the traffic ticket. She used to date the judge. Now, is that fair? Is that really fair? So, that's a question again. That's a question of, yeah, Adrian said no, but that's life. Yeah, that's a question of judicial ethics. In a situation like that, certainly if the attorney and the judge are no longer dating, and maybe it's been 10 years, there's probably no conflict of interest. But if they were, if they just had dinner the night before, or if they were on a date the night before, that attorney is not allowed to appear before a judge when he or she has a personal relationship with that judge. That is judicial bias. So in a situation like that, if a judge is actively dating an attorney, that attorney is not allowed to appear before the judge. The judge has to recuse him or herself from that case, and a substitute judge has to come in and rule to maintain the image of impartiality. So it's questionable. But at any rate, one side is not supposed to have a personal advantage like that with a judge. There was a judge in San Diego when I lived out there who had accepted a beautiful red sports car from an attorney as a gift for the judge's son graduating from high school. Do you see an ethical problem with that, Megan? Judge's son graduates from high school, and an attorney who regularly appears before the judge buys his son a brand new red sports car.
I mean, that doesn't surprise me, but I don't think it's a good idea.
Yeah, I think if they have it looks like someone is trying to influence that judge, right? Yeah, judges are not allowed to accept expensive gifts like that from attorneys that appear before them on a regular basis, because again, it shows an appearance of impropriety. So that's really getting down again to the paralegal is not supposed to have any ex parte communication with the judge. Anything where just one side is trying to get an advantage, trying to communicate with the judge, trying to give a gift to the judge, trying to give a gift to somebody in the judge's family, trying to date the judge, anything like that that will give them trying to exert some influence over the judge. That's unethical. And that's what this Rule 1.2 is talking about. The paralegal cannot really have those kind of communications with judges. We know that it happens because human beings are made of flesh and blood, but it's a violation of the rules of professional conduct. And I'm pretty sure that the judge in San Diego had to step down once it was discovered that he had accepted an expensive sports car for his son from an attorney. The judge was sanctioned for that behavior. And believe me, that wasn't the only thing that judge had done wrong. So, okay. B, a paralegal shall not communicate with a party the paralegal knows to be represented by a lawyer. So once, suppose you represent MasterCard, the company, and MasterCard has a credit card customer who hasn't been paying their bill. If that customer hires an attorney and decides to file bankruptcy, you as a paralegal are not allowed to get on the phone with the debtor, because that's a party represented by counsel. So you would have to talk to the attorney that represents the client. Any questions about how that works? Paralegal is not allowed to communicate, nor is an attorney allowed to communicate with a party who is represented by a lawyer without the prior consent of the lawyer. Because once someone hires a lawyer, then you're supposed to be talking to that lawyer, not the client directly. Rule 1.3, a paralegal shall maintain a high standard of professional conduct. Paralegal shall refrain from engaging in any conduct that offends the dignity of the decorum of the proceedings before a court or other adjudicatory body, and shall be respectful of all rules and procedures. A paralegal shall advise the proper authority of non-confidential knowledge of any action of another legal professional that clearly demonstrates fraud, deceit, dishonesty, or misrepresentation. If a paralegal possesses knowledge of future criminal activity, that knowledge must be reported to the appropriate authority immediately. So what do you think that means, Yolanda?
Can you repeat what you just said?
Sure. Rule 1.3 says a paralegal shall refrain from engaging in any conduct that offends the dignity and decorum of the proceedings before a court or other adjudicatory body, and shall be respectful of all rules and procedures. So what do you think that means? What kind of behavior is required from the paralegal in court?
It's required for her not to interact with them, for her to act professional.
Okay, this reminds me again of a situation that occurred in New Mexico when I lived there. There were a couple of judges who were coming to court with the black robe on and nothing underneath it. Now, do you think that's conduct that offends the dignity and decorum of the proceedings, Yolanda? I know, Adrian. Yeah, it has happened. This was in New Mexico. Judges were coming into court with the black robe on, but nothing underneath the black robe. Does that offend the dignity of and decorum of the proceedings?
Yes, it does, because he's not being professionalism, and he's not being true to himself of his occupation or what he stands for.
Yes, I thought it was very odd. I mean, it was in the newspaper, and
Wow.
yeah, so that would be an example. Really, when any legal professional, and most judges are attorneys, okay? So when an attorney, a paralegal, or a judge is in court, it's important to wear the appropriate attire, right? You would not come into court wearing sweats, for example. I watched some court TV yesterday, and a client, the defendant, came into court with his hair long and in a sort of a strange haircut, and the judge said, "Cut your hair before you come back into court," period. Because it offends the dignity and the decorum of the proceedings. There's a certain presentation, haircut. It may require a lady to wear pantyhose and high heel shoes. Whatever the decorum and clothing of the proceedings is required is what we wear when we go to court. And again, this comes from the English legal tradition. I'm sure you've seen all those people with those white powdered wigs. Fortunately, that is a tradition that's fallen by the wayside. But English judges, barristers, they used to have to wear that white powdered wig. And I was a judge one day, a substitute judge in small claims court in California, and I can assure you, I had clothes on underneath the black robe, and I was not wearing a powdered wig. But, you know, there is appropriate attire that should be worn in the courtroom. Yeah. And we all need to be wearing clothes underneath whatever it is that we have on. So, a paralegal shall advise the proper authority of non-confidential knowledge of any action or other legal professional that clearly demonstrates fraud, deceit, dishonesty, or misrepresentation. So, if a paralegal is aware that opposing counsel has engaged in fraud, deceit on the court, dishonesty, misrepresentation, perfect example of that would be what we talked about last week or the week before, a personal injury case where an attorney is representing a client who claims to be injured, and that attorney knows the client just went skiing in Vail. Okay. That would be, you know, trying to perpetuate a fraud on the court, claiming that someone is suffering from a disability when you know that they're able to go skiing, they can mow their lawn, they're outside playing hopscotch with their kids, they're playing baseball with their kids. That would be, you know, trying to commit fraud and deceive the court and being dishonest. So if you become aware of another legal professional that is trying to commit a fraud on the court, you should go ahead and, you know, advise the court of that. Let the court know that the next time you're in court. If a paralegal possesses knowledge of future criminal activity, that knowledge must be reported to the appropriate authority immediately, whether it is your boss, a client, or another professional. If you know that somebody intends to commit a crime, if a man, and this has happened more times than I care to admit, if a man is out soliciting guns for hire because he's tired of his wife and he's ready to get rid of her and get the insurance money. Sadly, it happens all the time. If paralegal becomes aware of that there is someone out and about looking for soliciting murders to you know, get rid of their spouse, that knowledge should be reported to the police. Any questions, again, about this high ethical standards that paralegals have to maintain? Okay, let's talk about legal malpractice. Legal malpractice is a tort. It is a civil wrong for which damages might be available. So a client can sue an attorney for legal malpractice. So let me get down here. A violation of a rule itself does not necessarily give rise to a cause of action against a lawyer. The ethical rules establish standards of conduct by lawyers. A lawyer's violation of a rule may be evidence of the breach of the applicable standard of duty. So attorneys would be sued for legal malpractice, which is the tort of negligence. Negligence is the violation of a duty which causes damages to the client. And if paralegals should engage in some negligent conduct or fail to file something with the court that causes the client damages, the attorney, as a supervisor, will be held liable for the paralegal's conduct under the doctrine of responde ad superior, which means the superior is the person who has to respond to the court. Courts have held that the negligence of a paralegal shows a deficiency in the supervision by the attorney. So the attorney can be held liable for legal malpractice for their own misconduct and the misconduct of a paralegal that causes damages to the client. When a non-lawyer, such as a paralegal, holds themselves out as an attorney through misrepresentation, then the paralegal could also be held liable for malpractice. And of course, that's also the crime of the unauthorized practice of law. So the unauthorized practice of law is actually a crime. Any person who's practicing law without a license in that jurisdiction, be it a lawyer or paralegal, that is a crime for which you can be imprisoned. Legal malpractice is a tort, which means that the client can sue you for civil damages. You're not going to jail as a result of negligence or a legal malpractice, but you could go to jail for the unauthorized practice of law because that is a crime. So when a paralegal holds themselves out as an attorney through misrepresentation, the paralegal can be held liable for legal malpractice. Attorney malpractice. Attorney malpractice is a failure to use reasonable skill and knowledge possessed by a member of the legal profession. The attorney's breach of duty must cause the client to suffer damages. Here's the classic example. The attorney fails to file the client's personal injury claim before the 2-year statute of limitation expires. Therefore, the client's action is time barred and the client cannot sue for personal injury sustained in an accident. And that happens much more often than we care to admit. I worked for a really busy law firm in San Diego for a while, and there were cases that we just couldn't get to. And some of the bosses, some of the partners would just open up a file and say, ooh, we were supposed to file something last year. And what they would do is go to court and ask the judge for an extension. And if the judge is nice, you get the extension. If the judge is not nice, you don't get an extension. In that case, that would be legal malpractice because the client has been damaged by the attorney's inaction. So for personal injury cases, sometimes the statute of limitations is 1 year from the date of injury. Sometimes it's 2 years from the date of injury. You know, if a child is involved or someone is disabled is involved, you get a longer period of time. So, but there is a period of time when the court closes its door to your case. So the client had better act quickly in getting an attorney. They've been injured, and the attorney had better act quickly in filing the complaint with the court before the statute of limitation expires, because if the attorney is bogged down with other cases and does not file the client's claim before that statute of limitation expires, that is legal malpractice. And the client, instead of suing the defendant or the insurance company or the other driver, the client's going to be suing their own attorney and getting the damages that way. So any questions about attorney malpractice and how that works? All righty. So we've been talking about the ethical rules and what happens when the ethical rules are violated. An ethical violation is a legal professional's failure to follow the ethical rules established in the particular state or jurisdiction. This includes violating the rules of competency. An ethical violation may or may not give rise to a cause of action for legal malpractice, because there might be an instance where an attorney violates the rules of professional conduct, but the client does not experience damages. But it could still subject an attorney or a paralegal to a disciplinary action. So the way the disciplinary action works is, for an attorney, the State Bar Association receives a complaint. And I'll give another real example from somebody I went to law school with. I'll even say his name, Scott. Scott took some money from a woman and promised to work on her divorce. He spent the money. It was a $5,000 retainer fee. He never worked on her divorce. She called the State Bar Ethics Hotline and said, look, I hired this lawyer and paid him $5,000 to work on my divorce. He never worked on the divorce. Well, the State Bar investigated that complaint, and they took actions against Scott. I believe that he was disbarred after that, and it wasn't his first violation. So it does happen to people I know. And so that's how the attorney disciplinary process works. As a result of violating these rules, an attorney or a paralegal could have their certificate revoked. The attorney could be prohibited from practicing law. They could be suspended. A lot of times somebody gets suspended from the practice of law for a certain number of years, and then they can, take courses and show that they've been ethical, and then they can come back to the bar. But this is very real. This is a serious matter. And again, a number of people that I went to law school with have been sanctioned and have messed up their careers. Let's talk about the Module 5 written assignment. So in this assignment, you're working as a paralegal, and your attorney has decided to take a last-minute trip to Las Vegas with some of his college roommates. However, his neighbors are coming into the office while he is away to finalize their uncontested divorce. So, does anyone see a problem with an attorney representing their neighbors in a divorce? He is good friends with them and he has agreed to represent them and guide them through the process. He's representing the husband and wife in a divorce. The final hearing is taking place while he's in Las Vegas. Does that sound responsible? He forgot to have the client sign a fee agreement, so he asked the paralegal to prepare a fee agreement for his usual hourly rate. Is a paralegal allowed to file a fee agreement? And
No.
meet with, go ahead, Adrian.
Oh, sorry. I thought you were asking. No, they're not. I mean, not
Okay.
well. They're not allowed to. They're not. They're not allowed to sign the attorney's name either.
Now, so we have some ethical violations here. An attorney is not allowed to represent the husband and wife in a divorce. A paralegal is not allowed to enter into a fee agreement. The attorney has instructed you to prepare the final judgment entry and sign his name to it. He would like you to go to court with the clients to ensure that they are in the right place and make them feel comfortable. Adrian, is a paralegal allowed to represent a client in court?
Oh, absolutely not. They're not licensed attorneys.
Can a paralegal ever go to court?
I think so. There's certain situations where they can do non-lawyer something I was reading about, but I didn't really go into it too much because you didn't ask us to. So, but I saw something like that in statutes and cases I saw.
Yes, a paralegal can go to court as long as the supervising attorney is sitting with them. So the supervising attorney just needs to be there. The paralegal can go to court and can make the clients feel comfortable and ensure they're in the right place and assist as long as the attorney is sitting there. The attorney cannot be in Las Vegas and send the paralegal in there to do it. And if there are any issues with the entry of the judgment or the judge needs any information to provide the necessary counsel to the clients, can the paralegal do that? Yeah, no. So we can see we have violations of the ethical rules. So your job here is to write a memo on the unethical conduct presented. Write a memo to your firm's ethics committee addressing your concerns over the attorney's plans for how the divorce case should be handled while he's in Las Vegas. Explain each ethical violation you're concerned about, including a legal analysis for each violation using case law and the ethical rules that apply to both attorneys and paralegals. An in-text citation to each specific rule that applies should be included. Address concerns relating to the unauthorized practice of law, fee setting, conflicts of interest, competence, confidentiality, and the duty to report, as well as any other ethical issues you perceive. So go back to those model rules we've been looking at, the ABA rules, the NALA rules, the paralegal rules, professional conduct, and let's see which ones are being violated here. Point that out in your memo. Consistent with your firm's practice regarding ethical concerns, you should also conclude with a recommendation for the proper course of action from this point forward. Your memo should be 3 or 4 pages in length, double-spaced, proper formatting, standard font, spelling, and grammar. You should use 3 primary legal sources, including case law, citations to the ethical rules for paralegals and attorneys. Your memo should contain the following sections: heading, caption. The facts can be very brief. The issue presented can be very brief. That initial answer can be brief, but the longest part will be the several paragraphs spent reasoning and discussing each ethical violation that you've observed. And then your conclusion on how that case should be handled going forward. And again, if you click on the assignment, there is a resource there for how to create a legal memo. And the tools you'll be using again is Microsoft Word, Lexis Advance, or Fastcase. The memo is due Sunday, and that date is wrong. That's May 9th. Sunday, May 9th. And I will fix that, and I will distribute that PowerPoint presentation. Any questions about how to do that memo?
I actually have a question. So I have
Yes.
two. So in the issues, obviously there's like a cajillion issues in there. So what I did was when I started the memo is I said, you know, these are the issues but I kind of numbered them. Is that okay?
Numbering is good.
Okay. And then my other question is, when I was writing, I did my, you know, brief answer and then my discussion, I started to write that. And what I did is I took each of the questions I had in the issues and I stated the question again and then wrote about it. Is that okay as well?
That's perfect.
Okay. Okay. Thank you. That was what I was wondering. Thanks.
That's a great way to organize your memo. So that's due Sunday, May 9th. Okay, well, that takes us to the end of our live session. And our live session question this week is, can a paralegal be held responsible for legal malpractice? Again, that answer is due Sunday, May 9th. So I'm going to have to fix that PowerPoint slide. So let's go. Let me share my web browser. Let's go into the online classroom and let's take a look at what is going on in the classroom this week. It's the web browser. I wish that would cancel that. Stop. I'm going to turn off my video because once again it's using up too much bandwidth. Let me go into the online classroom and we'll take a look at what is happening here. Blackboard Learn. There we go. I want to take a look at the grading rubric for this Module 5 assignment and see what the sample memo is that you've been given. Alrighty, Blackboard Ultra. There's our course homepage, and we're going down to Module 5, Consequences of Unethical Actions, and our assignment, which says correctly due May 9th. How do I write a legal memo? And over here is the grading rubric. There we go. So here's where your 30 points is coming from. Ethical issues and rules. 100% mastery would be proficiently identifies the ethical issues presented and provides advanced citations to the specific ethical rules and any on-point cases that you find on Lexis Advance. The next goal is your analysis and the application of the rules. An advanced analysis of the ethical rules in the application to the conversation with the attorney. What is your recommendation for how the case should be handled going forward? An advanced discussion of the proper course of action that would comply with the ethical rules from here on out. Mechanics. No errors in spelling, grammar, and mechanics, so just be sure to run your Microsoft editor, look for misspelled words, fix any words that Microsoft Word highlights in yellow, in red or blue. If Microsoft Word is highlighting something, that means there's a misspelled word or a grammatical error, so fix that. References, 3 primary on-target legal references. Again, the rules, the statutes, and the cases are the primary legal sources. If you want to cite to some secondary treatise that talks about the rule, that's fine. But that would be using some secondary sources, and you can see the rubric requires me to take off if you use secondary as opposed to And if you have no sources, you lose points there. So all I'm going to do is check off the boxes here on the rubric and just make sure that your paper meets the requirements. So let's take a look at this, how to create a legal memo. It's a Microsoft Word document. Okay, and here's a sample. So yeah, just follow the sample. And remember, the most important part is your analysis. Okay, any questions about that assignment? Thank you all for attending the Module 5 live session. It's really been a pleasure getting to know all of you this term. The Module 6 live session will be a pre-recorded video that I'll post on Sunday. It's primarily going to be a quiz review because there's a quiz in Module 6, and that live session is designed to get you prepared for that quiz. So watch the video and then take the quiz. And your module, you're welcome. Thank you so much, Adrian, Megan, and Yolanda.
Thank you for giving us the lessons and teaching us. I really appreciate it.
It's my pleasure. It's been a joy having you all in class, and thanks for your excellent participation in the weekly live session.
Thank you.
Have a great week, and I will see you all in cyberspace.
Yes, ma'am.